All right. So this video is going to focus a bit on some of the a bit more modern issues that are related to the push for racial equality. So we talked about some of the gains predominantly in the 1950s and 60s that were granted through court cases, through laws, through amendments. But there are a couple other issues that I just want to address very quickly. In 1968, there was a law passed called the Fair Housing Act. Pretty significant law in the scope of American history, and that it really deemed it to be illegal to refuse to sell or rent housing to people based on their race. For a long segment of time in American history, through 1968, there were many sort of official government policies, unofficial actions taken by citizens that really made it difficult for African Americans to have equitable access to housing. There are many barriers to that, and this made it illegal. But one of the things I want to point out is that because these barriers have been in place for such a long time, it has made it very difficult to sort of escape some of the aftermath of generations of discriminatory government policies when it comes to housing and access to housing. So, for example, de facto segregation is segregation that still is in effect today or still exists today. It's not legally enforceable segregation like de jure segregation was. I mean, that was ended in public schools by the Brown v. Board decision and ended in all other areas of American society by the 1964 Civil Rights Act. But there is still segregation that exists today. It's not legally enforceable segregation. Law is not being used. Current law is not being used to enforce it, but it is still in existence. I guess the point I want to bring up is that though this type of segregation is no longer illegal, it's because of the legalized policies that used to be in existence that this still remains. So, for example, the New York Times back in 2015 basically did like a mapping exercise where they attempted to use census data to map out all of the major metropolitan cities in the United States and basically plot where people lived according to race. And you can Google it if you want to see more of sort of like what they came up with. But this is like the New York, New Jersey area, and you can see just how visually sort of like stunning like this is. In fact, I will show it to you briefly. This is sort of like their website, and every dot on the map that's a blue dot represents African Americans, orange represents Hispanics, red Asian, green are white, and then purple would be others. And you can see just how visually stunning the differences are. That's New York. Philadelphia is no different. Boston, no different. Houston, no different. And that largely people still live in segregated communities. Now, this is not like legally enforceable by law. It's illegal to deny people equitable housing because of their race. But there are many sort of discriminatory policies that were in effect for such a long time that made it very difficult for African Americans to move into areas like the suburbs. And the after effects of those policies that are no longer illegal still kind of live on today, promoting much of the segregation that you still see, although it's not legally enforceable. Right? So that's de facto segregation. And then one of the other topics I want to touch upon briefly is just affirmative action. This is a fairly sort of like controversial policy. It's often debated in that we're going to focus on it in the area of like higher education, like colleges, and it's the policy of sort of some favorable sort of treatment or preferential consideration for groups that have historically been the target of discriminatory policies in our country, whether it be racial minorities or like women, that, again, acknowledging that their access to areas of higher education perhaps has not been equitable. It hasn't been equitable throughout our country's history, and that there have been barriers placed in front of students from those groups in terms of obtaining access to college. So this is the attempt by some schools, not every school implements this, to provide some sort of preferential consideration for groups that have been discriminated against, right? So just the two pictures tell the tale of sort of the argument, and you have some people that vehemently defend affirmative action, saying it's necessary to sort of level the playing field, that many college campuses for a long portion of our country's history weren't very diverse communities, and that affirmative action would go a long way into promoting diversity on college campuses. And then you see the signs of the right. There are those that oppose affirmative action that look at preferential consideration given to minorities, whether it be racial or gender, is reverse discrimination, right? And that you should never take into consideration a person's race or gender when deciding who gets admitted to college, right? So the Supreme Court has taken some stands on the issue of affirmative action. The first case involves University of California in 1978. And this basically dealt with racial quotas that the university had for its admissions. X amount from this group would be let in, X amount from this group, X amount from that group. And the Supreme Court had an issue with that. They believed that was too reliant on race. So this sort of begins the Supreme Court's sort of stance on the issue of affirmative action. And it's sort of still in existence today, in which the Supreme Court said that they were comfortable with race being a factor in the college admissions process, but not too much of a factor, and that having rigid, strict racial quotas requiring a certain number of each racial group to be admitted every single year was too strictly reliant on race, and that they struck this policy down as being unconstitutional. However, they did leave the door open in future situations for race to be a factor, as long as they could be comfortable that it wasn't too much of a factor. So that's a bit arbitrary, and what this has done is it has basically set the scene for a bunch of cases being brought forth to the Supreme Court over the decades since 1978, in which universities' affirmative action policies are being challenged as being too much reliant on race. So there are two cases involving the University of Michigan, both in 2003. Bollinger is mentioned in both cases because at the time Bollinger was the president of the University of Michigan, right? And the University of Michigan's undergrad admission plan was struck down in 2003 because, like the California case above it, it was deemed to be too reliant on race. Their system of admissions required the earning of 100 points, that you would earn points for your academic accomplishments. For example, a perfect score on the SATs earned you approximately 12 points. 100 points would gain you admission to the university, whereas being part of a disadvantaged economic group or a racial minority group or an underrepresented racial minority group on the college campus would earn you 20 points. So the interpretation of the Supreme Court was that this admission policy was too reliant on race, and based on the precedent they established above, they struck that down. But at the same time, there was a case involving a challenge to their law school admission plan. And their admission policy in this case was upheld because race was only a small factor. It wasn't the same point system that was described in the Gratz case. Again, these are just a handful of cases that have occurred after the California case in 1978. But the Supreme Court has been relatively consistent that they're okay with race being a part of the puzzle in terms of college admissions, but they just don't want it to be too much of a piece of the puzzle. So again, that's a bit arbitrary and difficult, but this is sort of the position the Supreme Court has put itself in. And affirmative action policies aren't just limited to education. Hiring practices for the government and things like that have all been sort of in the realm of affirmative action. So again, this is sort of one of the modern sort of issues that's often debated, that's sort of dealing with sort of the aftermath of a lot of the civil rights stuff that we've previously talked about.